Hi, everyone. Welcome to today's webinar. I see that we have people joining, so I'll give everyone a minute to join and get signed on. My name's Nicole with the San Diego Law Library, and I have with me today our speaker, Barbara Treash-Osio, who will be discussing probate and conservatorship. I just have a couple of housekeeping things to do before we get started. First, you should have already received the handout for today's webinar. If you haven't received the handout, please email refdesk@sdlawlibrary.org. Again, that's refdesk@sdlawlibrary.org. And this can be found on our website as well, and we'll resend the handout. Next, for those of you who are here for CLE credit, this class is for 1 hour of general participatory MCLE credit. We'll be issuing the MCLE participatory credit or certificate to you after today's class, once we can verify those of you who have attended today. So please look out for that later in your spam and junk folder as well. If you're attending today's session via audio and dialed in using your phone number, please send us an email with your name, phone number, and California bar number if you'd like to receive an MCLE certificate. Again, you only need to do this if you are attending today's session by dialing in using your phone. This is an interactive presentation, so you have the opportunity to submit questions during the presentation to our speaker, but we do ask that you utilize the Q&A function. You may ask your question either anonymously with your name or with your name, whichever you prefer. And we'll try to get to as many as possible today. Lastly, you'll also receive a link at the end of this presentation, and we would appreciate any of you who took the time to fill out that survey and give us some feedback on today's presentation. And with that, I will turn things over to our speaker, Barbara Treash-Osio.
Okay, hello everyone. So I'm Barbara Treash-Osio from Legal Aid Society. Our phone number's there if you ever want to call us. And I'm going to talk about if conservatorships even needed, alternatives to conservatorship, and the process. It's quite a process. And just to tell you a little bit about our conservatorship clinic, it is first come, first serve. There's no appointments. It's not legal representation. We provide information and forms, and there are our hours and locations. We do look for volunteer help. So if there's attorneys out there who are interested in volunteering at Legal Aid, you can apply through our website. Again, here's our hour and location here. So the first thing you need to think about when you're thinking about conservatorship is it necessary? Is it needed? Alternatives to conservatorship. Conservatorship should only be granted if it's the least restrictive way to protect a proposed conservatee. And all adults have a rebuttable presumption of capacity. So having a disability doesn't mean that automatically that you need to be conserved. There's a rebuttable presumption of capacity. Things that we think of as alternatives to conservatorship is something like a supported decision-making agreement. That's kind of a newer thing. And the most important thing to know about supported decision-making agreements is they are less powerful than advanced healthcare directives and durable powers of attorney. A supported decision-making agreement, it basically just means that the supporter gets to be in the room with the principal and help them make decisions. If you have a valid advanced healthcare directive or durable power of attorney, you could act independently of the principal. But those documents, the person who signs them, the principal has to have capacity when they're signed in order for them to be valid. Things like being a representative payee, that is very important for Social Security, possibly VA benefits, maybe some other things might have a representative payee. Representative payee for Social Security is the one that I see the most. You do not need a conservatorship of the estate to become somebody's representative payee for their Social Security benefits. That is something you would arrange directly with the Social Security office. And you could become somebody's representative payee, whether they have capacity or don't have capacity, either way. It requires an in-person meeting with the Social Security office, and you just go there or schedule an appointment, but it does require an in-person appointment. And The probate code does provide for healthcare decision makers and surrogates, even when there is no conservatorship. But this doesn't extend outside of the healthcare facility. This is another possible alternative. Like if somebody's in the hospital right now, the probate code does allow for non-court options for designating a surrogate. So those are good probate codes to show people in the healthcare facility if they are not letting you talk to them, talk about your loved one who needs help making decisions, because there are alternatives to going to court. Conservatorship might be good for the long run, but you don't necessarily need a conservatorship today just because somebody's in the hospital. So look at those codes if that is relevant to your situation. Sometimes healthcare providers need to be made aware of certain provisions of the probate code. So conservatorship is a court proceeding. It's a protective proceeding. It's clear and convincing evidence. So the evidentiary standard is higher. A conservator is appointed to care for another adult, which is the conservatee. Conservatorship is for adults. It's not for minors. You can apply when they are 17 if it is somebody who you expect to need a conservatorship upon their 18th birthday. But conservatorship is for adults. It is not for minors. The guardianship is for minors. That's a whole different topic, but which is also part of probate law, but it's a different area. And conservatorship is for people who cannot manage their personal needs or their finances. So the proposed conservatee, that is the disabled adult. The proposed conservators, so those are the people applying to be conservators. There can be co-conservators. Usually we like to have 2 or 3 conservators. One can also be fine, especially if the conservatee is an older person. But if you are conserving somebody who is young, it is ideal if it's appropriate, if there's some appropriate people, to have 2 or 3, so it's more of a durable plan. Because if you are conserving a 17, 18, 19-year-old, that conservatorship could be in place for decades. And so having 2 or 3 conservators would be a good idea. There's an order of priority, but that doesn't normally come into account, probably only if there's multiple people sort of arguing over who should be conservator. And the petitioner is the person who is kind of speaking on behalf of they're the ones responsible for filing the case. And normally they are also applying to be the conservator themselves. The co-conservators do not have to be petitioners. There can just be one petitioner, and then there can be co-conservators as well. And the petitioner could be anyone interested. It can also be a public entity. If it's something like the public guardian, that would be handled by county council. The public guardian is, in certain instances, is going to be obligated to petition, or the court could order them to petition or to do an investigation. There can be objectors, so someone else in the family could object, or a friend could object, even the conservatee could object, or the proposed conservatee could object, and they even can demand a jury trial. The proposed conservatee can. If it's just competing petitioners, then that would not be a jury trial. So there's a lot of forms. Those are the forms that we normally need for a conservatorship of the person. There's probate packets available on the website if you wanted a packet of all the forms. So there's conservatorship of the person and conservatorship of the estate. And I do not help with conservatorship of the estate, with very small exceptions. If the estate is very tiny and no bond or accounting would be required. So there are exceptions to the bond requirements and accounting requirements. There's a lot of additional forms and things that are required for conservatorship of the estate. That's outside the scope of the conservatorship clinic. But just so you are aware, there's conservatorship of the person, there's conservatorship of the estate. You might be applying for both. So that very much depends on the situation. What I'm helping with is mostly limited conservatorships. About 80% of what I'm doing is limited conservatorships, which is people who grew up with their disability and normally don't have any estate. But yeah, conservatorship of the person and conservatorship of the estate. There's limited conservatorship, general conservatorship, and temporary conservatorship should only be applied for if it's urgent. You should not apply for a temporary conservatorship in every conservatorship case. You should think about, is something bad going to happen if we have to wait 3 or 4 months for this conservatorship? And then there is also the LPS conservatorship that is brought by the county. That is for mental health situations, more severe mental health situations. Essentially, the county has to decide that it is required. It's not something that family members can directly apply for. So for limited conservatorships, the purpose is to protect the developmentally disabled person, preserve their rights. And the most common developmental disabilities are intellectual disability, cerebral palsy, autism, Down syndrome. And they are very customizable, the limited conservatorships. There's 7 powers and they don't have to all be granted. So it's a very customizable conservatorship. Again, conservatorship is for adults, but you can start the process when somebody is 17 years old. If you start the process when they're 17 years old and it gets granted while they're 17, the order will have a future effective date. And the effective date would be the 18th birthday. So developmental disabilities are originate before the age of 18, and they're expected to continue indefinitely and constitute a substantial handicap. For developmental disabilities, the regional center report is required for the limited conservatorships. And that is important to keep in mind. You cannot get a limited conservatorship without a regional center report, and the regional center is very backed up with new people enrolling. So if a limited conservatorship is something that you need to apply for or need to help somebody else apply for, try to get them enrolled in the regional center. It's before you start the conservatorship process, or emphasize that that is a prerequisite to getting the conservatorship. And ideally, you should also talk to your regional center worker about whether or not conservatorship is even needed. Not that you have to follow what they say. I have seen the regional center maybe recommend only 4 powers and still have the person get all 7 or something like that. But ideally, discuss it with the regional center and be enrolled in the regional center before you apply for conservatorship. So the 7 powers in limited conservatorship are listed here. Part A of this statute actually does just talk about care, custody, and control. And sometimes you might need to talk about the Part A and argue that, because the problem is there are things that come up that aren't listed in the 7 powers. But certainly the 7 powers have to be enumerated in order to have them. So for example, if you didn't have power number 7, then that would mean that you had no authority to make educational decisions. If you didn't have power number 6, that would mean that you have no power to control their relationships, so on and so forth. So the enumerated powers you most definitely only have if they are listed in your orders and letters. The duties of the limited conservator: you have to arrange for their care, decide where they're going to live, make arrangements for their health care, meals, clothing, personal care, all of that. You also are obligated to make sure that they are developing self-reliance and independence to the extent possible. You have to, treat them with respect and consider their wishes. So normally it's really obvious whether you should apply for a general conservatorship or a limited conservatorship, but there actually are cases where it's a little hard to figure out which one you should apply for. For example, let's say somebody had a developmental disability, but it wasn't really that severe, and then maybe they ended up getting a something happened like a brain injury. So that could be a situation. Another one would be people who immigrated to the US in adulthood, and it's a little unclear what their disability is. They just can't communicate. So there are situations where it's actually a little unclear whether you should apply for a general or a limited conservatorship. Just so you know, according to the statutes, if you apply for a general, the court can deem it a limited, but realistically, the court is probably going to request you to do an amended petition instead of just deeming it a limited conservatorship. So if you apply for the wrong kind, most likely the court's going to ask you to do an amended petition. And then if the developmental disability is very severe, there is a possibility of the judge granting a general conservatorship instead of a limited, but I don't think that happens very often, if ever, or very, very rarely. You would have to articulate why the limited conservatorship with all 7 powers would not be enough to meet the needs of the conservatee. So that's that. The powers and duties of the general conservator, you have the fiduciary duty to act prudently and in good faith, take action in their best interest, accommodate their wishes, care, custody, and control, personal health care decisions, fix the least restrictive residence. So the least restrictive residence, that would be things like not putting them in a facility if it's not needed, if their preference is to stay at home and that meets their needs, or the least restrictive type facility that would meet their needs. So there are powers that must be asked for separately, even in a general conservatorship. That includes medical power and the power to marry, or the power to consent to marriage. So people almost always ask for the medical power if you are asking for conservatorship. It's just rare for someone to want, or at least conservatorship of the person. It's rare for someone to want conservatorship of the person and not request medical power, but it is possible. And the power to consent to marriage, that is actually something you don't see that often in general conservatorships. At least it's not something that people normally care about in general conservatorships that I help with. But both of those powers are in the listed 7 powers for limited conservatorships. The language regarding medical power is a little bit softer in the limited conservatorship. It's more medical consent, whereas in the general conservatorship, the medical power is about exclusive authority. So if you compare the medical language, the medical power language in general and limited, it's a little bit different. But the 7 powers includes medical and marriage, whereas in generals, you have to separately and specifically request those 2 powers, but everything else is just sort of, general. But yes, asking for a conservatorship of the person without medical authority is unusual, but possible. And you have to ask for it if you want it. So the dementia powers, or what used to be called the dementia powers, are 2 add-on powers that you must specifically ask for, and they must specifically be granted. There must be the diagnosis of a major neurocognitive disorder, and the 2 add-on powers are the placement in a secured perimeter care facility to control wandering, and also the administration of the psychotropic medications that are specifically for dementia because those can be considered a chemical restraint. So you have to have the specific authority for those 2 powers, the placement and the psychotropic medications. So the conservatee will always retain rights. The conservatee will always retain their rights they will definitely always retain the right to ask a judge to change the conservator and the conservatorship. Now, most conservatees do not have a salary, but if they do have a salary, then it's their money. they could have they could still be able to make a will. That would have to be separately challenged in the will. Them being a conservatee wouldn't automatically mean they couldn't make a will. And that's because the capacity to make a valid will is lower than the capacity to contract. They could have the right to marry if that wasn't granted to the conservator. They're generally going to have the right to receive mail and visits and telephone calls, unless there was a specific reason why they can't. They will always have the right to be represented by an attorney. They're going to have the right to vote unless the judge says that they are not, and that power doesn't go to the conservator. So either the conservatee keeps their right to vote or that right to vote just disappears. And then unless medical power was granted, they will have medical power, and they could have the authority to enter into business transactions to meet their necessities of life. So there's limitations on the conservator's power. You can't place them in a mental health treatment facility against their wishes. Only the LPS conservator can do that. Cannot administer experimental drugs, cannot authorize convulsive treatment, cannot have the conservatee sterilized. There is a special petition for having the conservatee sterilized, but I've never been aware of that happening. I think there would have to be a reason why regular birth control couldn't work. So LPS conservatorships, those are initiated by the county. So that's not something anyone in private practice is going to be doing beyond advising people. I have to be gravely disabled. It's initiated by the public conservator. Just so that you are aware, the so-called permanent one, which isn't really permanent because it expires after a year unless it's renewed. But for the permanent LPS conservatorships, it actually can be a family member who's the conservator, but that's because they're the designee of the county. They still weren't the ones who started the case initially. And the conservatee will be represented by a public defender in this case. And the standard in these cases is beyond a reasonable doubt. For probate conservatorship, it's clear and convincing evidence. So for LPS conservators, you can place them in a psychiatric facility against their wishes. While you can't put them in a mental health care facility against their wishes, there is probate code sections that indicate that in general, healthcare includes mental health care. So I think if you have a probate conservatorship that includes medical care, and as long as it's not placement against the person's wishes, you should still try to manage their mental health. Unfortunately, sometimes I think psychiatrists think that they can't talk to probate conservators at all. I don't think that that's true. I think it just means no placement against their wishes. If it's something like ordinary outpatient mental health care, I think that is included in healthcare in general, and probate conservators should try to manage that for their conservatee. So this is our flow chart or our timeline for conservatorship. It goes on and on and on. First thing, you figure out who's going to be the petitioner. Is there going to be co-conservators? Make sure the conservatee lives in San Diego County. The jurisdiction is based on where the conservatee lives, not based on where the petitioner lives. Think about if conservatorship is appropriate and what kind. There's a lot of information to gather. And do you have appropriate conservators? The conservators will be screened, and that's Form GC 314 is the background screening form for conservators. There's a lot of forms to file. They are updated periodically. A number of the forms were updated in January of this year, January 2025, and they are periodically updated. Attorneys are now required to file electronically, but I'm helping ProPERS, and they almost exclusively are filing in paper, in person on the third floor probate business office. And I don't file paperwork for the people I assist. So that is something to keep in mind. If there's any court-appointed attorneys out there listening or listening to the YouTube video later, I don't file things for the petitioners that I help ever. They file things themselves. So I have no control over whether they file and when they file and if they file. So the fee waiver is based on the conservatee's income, or at least this one is. You could still use the normal fee waiver if that was advantageous in your situation. But the fee waiver that I would normally use is this one, because this one is almost always is advantageous to the people that I assist, because it's based on the conservatee's income, and the conservatee generally doesn't have any income in the cases that I help with. They can automatically get a fee waiver if they get Medi-Cal, SSI, or IHSS, and those are typical in the situations that I help with. So yes, if the conservatee gets SSI, IHSS, any of those benefits, then you qualify for a fee waiver. If they have no income, you qualify for a fee waiver. You have to include, if they're married, you have to include their spouse's income, but you do not have to include the income of, if they're like 17, 18 and you're applying, you do not have to include parents' income. So that is on the fee waiver form itself. So yeah, it's the conservatee's income, and they usually don't have any if it's a conservatorship of the person only situation. This is the petition. This form is not confidential. Most of the forms in conservatorship cases these days are confidential, but the Form GC 310 is not a confidential document. You need to make sure that you are not checking too many boxes or checking inconsistent boxes. If you want a sample, you can email me later and I can give you a very basic sample of how these forms should be filled out for limiteds or generals. Because if you check too many boxes or inconsistent boxes or not enough boxes, your paperwork is going to be full of defects. And the probate examiners go through all of these forms very carefully. So 5C, you're going to talk about why you need a conservatorship. The main things that we care about for a conservatorship of the person is physical health, food, clothing, and shelter. In this case, if you are applying for conservatorship of the person only, you would leave 5C2 blank. 5C2 is about conservatorship of the estate. So if you are applying for conservatorship of the person only, you want to leave all of the estate parts of the form blank. First and second degree relatives, they need to be noticed in conservatorship cases. And it's much easier to just notice these people than have this obligation waived. So just let them know, even if you don't have a relationship with them. So first and second degree relatives are parents and children, grandparents and grandchildren, brothers and sisters, and spouse. And then you can, if someone is deceased, you still will just list their name, their relationship, and say that they're deceased. If they're minors, you have to list their age. If they're adults, you do not. And then just to make it clear to the examiner that you're accounting for everyone, you can just list that there's no spouse, no grandchildren, etc., if that's the situation. This due diligence box, this is if the conservatee is not the petitioner, and the conservatee is never the petitioner. At least that would be a highly unusual situation. I never help with that at the clinic. That there would be something strange going on where a conservatorship was more advantageous than a power of attorney or advanced healthcare directive, and the conservatee was actually applying for it. But that isn't something that most of us ever see. So if that's not your situation, then you have to do this due diligence declaration, due diligence attachment. So the due diligence attachment, ideally, you know where all the relatives are. So then your attachment 3F1 is just going to state that you know the whereabouts of the relatives. And then your attachment 3F2, it could say why you think the conservatee prefers the proposed conservators as their conservators, or that they can't, or that it can't be determined what their preference would be. This is a confidential form. This is a local form, PR020. It's a local form. It's confidential. It's primarily for the court investigator and the court-appointed attorneys. This is another confidential form. In this form, you are required to consider alternatives to conservatorship. So that is part of your case in a conservatorship case, is to say that you considered alternatives and that they couldn't work for you. And I've actually found that it's fine to use conclusive kind of conclusory language like this, like they just cannot create it. But you are obligated to actually consider all of these alternatives and just at least say that there's a reason why you can't do those alternatives. So the 314, this is to screen the conservators. This document is confidential. This document is only for the court. Some of the confidential documents are also for the court-appointed attorneys, but not the 314 is only going to be for the court. It is a background screening for the proposed conservators. Make sure that they're appropriate. Sometimes people with past crimes or things like that do need to apply for conservatorship over a close family member, and they could be approved, but that's where this form, where you disclose that and where the judge can investigate if you're still an appropriate conservator. Medical declarations, these forms changed January 2025. The form is much longer now. The GC 325 is a one-page document, which is just about attendance. So if the proposed conservatee can attend, you can skip that form. The form GC 335 is 6 pages now. Used to only be 3 pages. You're going to want to fill out the caption and fill out 1 and 2, and then the rest is for the doctor. The duties of conservator, this form is nothing to fill out. They just sign it. It is an important read, though. It's like a summary of the handbook, which is like their obligations. The handbook is lengthy. It's 318 pages. But a lot of it doesn't apply because certain parts only apply to certain types of conservatorship, because it has sections about conservatorship of the person, about conservatorship of the estate, about limited, and about general. So they just have to sign that they have a copy of it. And this GC 348 is kind of a summary of that handbook. So once you have filed, you got to move on to notice and citation. Citation is personal service to the proposed conservatee. It doesn't matter if they don't understand it, they need to be served anyway. Remember that the default rule is that all adults do have capacity, so you have to prove that that's not the case. So the proposed conservatee gets served, and 15 days notice, minimum can be longer than that. Realistically, the court-appointed attorney for the conservatee does waive this requirement sometimes, especially like remember what I'm helping pro per, so I'm not helping them serve anyone. And people have a real hard time sometimes with the service. So this can be waived, it frequently is, but the law does, you do have to do this, whether they're going to understand it or not, until and unless the judge decides to waive this requirement. And then there's people that need to be served by mail. So you serve the first and second degree relatives by mail. You serve children, also children, as long as they're 12 and older. And even if they're under 12, if they don't live with an adult who's being served. So children could also be required to be served. The regional center has to be served if it's a limited conservatorship. By statute, they need 30 days notice, but realistically, you should give them much more notice than that, like as much as possible. The regional center is quite behind in doing the reports. And then more unusual situations, there are other entities that need to be served. So if you were not able to list all of the relatives in your petition and you still haven't found their address, you can do a due diligence form. We have a local form, PR 182, where you can show that your efforts to find the location of the missing relatives. And there is the possible alternative of having relatives that are entitled to notice just sign a waiver of, if they're, if they're local and they're not opposed, then that's just one piece of paper that gets filed instead of all of these copies and postage. So that's another possibility, is a waiver of notice. So next, court-appointed attorneys and investigator and regional center reports. So court investigator reports, this is for general conservatorships, usually not limiteds. After the conservatorship is granted, there's going to be court investigator visits periodically for both limiteds and generals. But normally there's not a court investigator report in limiteds pre-hearing, but there is for generals. And that could be unannounced. There's a cost unless it's waived. It is waived a lot. A lot of conservatorships are conservatorship of the person only in pro per. And so there are a lot of cases where these fees do not apply. And the report is supposed to be in at least 5 days before the hearing. So the regional center does a report, confidential report. They need to do a recommendation on each of the 7 powers individually. And that report is supposed to be in at least 5 days before the hearing. And again, this regional center report is required for a limited conservatorship. A lot of continuances in conservatorship cases are due to this report not being in. So the court-appointed attorney for the proposed conservatee also must do a report. The court-appointed attorney represents the proposed conservatee's wishes, assuming their wishes can be determined. They have to try to meet with them and try to communicate with them and see what's going on. And the court-appointed attorney is often paid by the county of San Diego. If they're not paid by the county of San Diego, they are actually paid from the conservatee's estate, but the county of San Diego is normally the one paying the court-appointed attorney. You can check your probate notes to try to correct defects, if any. Defects can cause delays. The probate examiner notes are usually available about 3 weeks before the hearing. There isn't any exact time when they're going to be available. It could be 4 weeks, it could be 2 weeks, but around 3 weeks lately seems to be pretty normal. A lot of the times the defects are just for not giving notice or something, like just not doing something you were supposed to do, like you didn't file the capacity declaration, or you haven't filed your notice of hearing forms yet. But then if there's defects in the petition itself, if there's defects in your initial forms, you can also do a supplement. You can use local form PR 177 for response to probate notes. And yeah, some defects also can be listed in there that are not caused by the petitioner. Some defects are also can be things like missing reports, and the petitioner can't really do anything about that. So other than maybe call the court-appointed attorney or call the regional center. If you have defects that are really strange that you can't figure out, try to talk to the probate examiner about it, because they're the ones that wrote the defects. And now you want to ideally do your proposed orders and letters before the hearing. So proposed order, you really want to do that before the hearing if at all possible. The letters are signed and dated by all conservators. So you only submit those at the same time as the 340 pre-hearing if the proposed conservatee will be 18, because the court will not hold on to the letters. Cannot be issued until the conservatee is 18 years old. The order can have a future effective date, but the letters do not. So proposed orders and letters together at the same time, or you do the proposed order first. But yeah, it's better to do these pre-hearing when it works out to do it pre-hearing. If you're submitting orders and letters after the hearing, then they must strictly match the minute order, and you might have to wait for the minute order to be available. So when it's a proposed order and letters that are submitted before the hearing, the courtroom clerk can make the judge or the courtroom clerk can make minor adjustments to the proposed orders. Once if it's not pre-hearing, once it's after the hearing, then it's the probate business office on the third floor who's handling this, and they won't approve it unless it matches the minute order. And then if the minute order is wrong, you need to do a nunc pro tunc to correct the minute order. So try to submit those orders and letters pre-hearing when you can. So the hearing, you can observe first if you want. The conservatee should appear unless a doctor excused them. The judge sometimes talks to the conservatee, just brief questions. If there's defects, the judge might waive the defects or there will be a continuance. Somebody will ask for a continuance. If there's an objection, there can be a continuance. Normally people can object orally once, but then they would have to actually file paperwork. They would actually have to file objections. So after the conservatorship is granted, there's still more forms. So one of the things that happens a lot with the people that I help, because they're pro per, the judge tells them they're all done, or the court-appointed attorney tells them they're all done, but they're not done. So don't tell pro per petitioners that they're done. Tell them to go back to the conservatorship clinic. So after the conservatorship is granted, there's the GC 341 that is due within 30 days of the conservatorship being granted. You need to mail the GC 341 with the GC 340 to the conservatee, court-appointed attorney, first and second degree relatives. The care plan, these also just changed in January of 2025. It's due within 120 days of appointment. And this is more work than it was before January, because there's two forms now. Part 2 is usually not required for limited conservatorships. And also for limited conservatorships, you usually only have to do part 1, part of part 1, not even the whole document. However, if that's for limited conservatorships where a parent is one of the conservators. If it's a limited conservatorship where it's only like a brother or sister or a cousin or something like that, then they have the same obligations as for a general conservatorship, all of part 1 and part 2. And then the service requirements for the care plans is also, it's pretty detailed. So the GC 355, it's the conservatee's attorney, and the first degree relatives. But if there's no first degree relatives, then it's the second degree relatives. And then the GC 356, it's only the conservatee and the conservatee's attorney. And if there's, but also the conservator of the estate, if there is a conservator of the estate. So it's very, very complicated, especially considering that most petitioners in conservatorship cases are pro per. This is a lot. This is a lot. Review hearings get scheduled if they don't do their aftercare forms. Review hearings also get scheduled if there's any problems, things like APS gets involved. So get those forms in. Those deadlines for the aftercare forms, the 30 days and then 120 days, that's what the statutes say, but usually there's not much consequence for filing them a little late, because the court, it takes a while for the court to send out your letters that you're failing in your duties, and then it takes a little while longer for the court to schedule review hearings. So the deadline is 30 days and 120 days, but just do it as soon as you realize that you didn't do it yet. There's an orientation class that you are sometimes ordered to do in general conservatorships, normally would not be required in limited conservatorships. And that can be accessed online. There is a certificate to prove that you attended it and get it filed. That's a local form. Your proof of conservatorship is your letters of conservatorship. You should have a certified copy, a recently certified copy, and you give this to anybody who needs proof that you have conservatorship. And review is on, there's court investigator visits every so often. Review is ongoing. So in these cases, when you look up the register of action, even after the case has been granted, it will say pending because review is ongoing forever. So you always have to keep your address current. You always have to be available for court investigator visits every so often. You have to keep your address current. If you're going to move out of state, the court needs to know that. You normally have to just apply again in your new state. There's some transfer for generals, nothing for limiteds, but even the transfer, even the interstate process for transfer of general conservatorships is a bit complicated. If you need more info, you can refer to the handbook. If you have the small estate and you're doing the annual and you have your accounting waive, there is an annual declaration for that. You're obligated to have a current photo or a recent photo of the conservatee. And conservators can be removed if they do anything that's inappropriate, any reason that the court deems is necessary for the conservatee's best interest. The conservatorship terminates upon the death of the conservatee. There is a form for that, like there's a form for everything. And anybody can petition to terminate the conservatorship. So probate conservatorships have no expiration date. As I said earlier, LPS conservatorships expire after a year unless they're renewed. Probate conservatorships have no expiration date. So they continue until the conservatee dies or they are terminated by the court. However, anybody can apply to terminate the conservatorship, and here in San Diego, it's local form PR 187, and the burden is not on the conservatee. It used to be, but now for terminating the conservatorship, the burden is not on the conservatee. It's still on the conservator about why the conservatorship should stay. Although occasionally it's the conservator petitioning to terminate it. And then it's a little bit more complicated because the court might be wondering if there should just be a different conservator. If conservators die, you can add conservators, you can remove conservators, you can seek amended letters. That's why you might need recently certified letters, is because the conservatorship might be 20 years old, but there might have been changes to who the conservators were. So that's why people might expect recently certified letters. Okay, so if you have questions for me, please email me. And then Legal Aid does accept volunteer attorneys. So if you are interested in that, just apply through our website. And now I think, yeah, we have some time for questions.
So the first question that we have is it recommended to apply to get the regional center report prior to when an individual turns 18 since the center is backed up? Or are you unable to start that process until after the individual is 18?
So the main thing is just making sure that they're enrolled in the regional center, and you can let them know that you plan to apply for conservatorship, but they're not going to do their formal report until you apply for conservatorship. So you can apply for a conservatorship when they're 17. It's just that if you apply for conservatorship when they're 17 and it's granted while they're still 17, the order has a future effective date. So you don't so much have to try to get the report before they're 18, just make sure they're enrolled before they're 18, and just they're enrolled before you apply if possible. And ideally talk to the regional center worker about it before you apply.
Okay, and then somebody said, what forms do I use to add a new and/or alternate conservator for an adult child?
You do have to do a new petition. So if you already have a conservatorship case with like one conservator, you just have to do another petition, and it's under the same case number. Normally, the judge will not require a new doctor's capacity form, but you do have to do a new petition requesting the new conservators be put on there, and it requires a new court date and all that. So it's a process.
And I think that this one kind of goes hand in hand because somebody else asked what happens if a conservator dies and there's not a co-remaining conservator. I think you mentioned that on the last slide that we just went over.
Yeah, so you can apply to add people if you're only trying to remove someone's name and that's it. You don't have to go back to court for that. At least you normally wouldn't have to. You could just apply for amended letters through the business office that just have like the one person's or whoever's left on there. But if you're going to use that time to not only remove someone but also add someone, then it does require a new petition and going back to court.
Okay. And then the last question that someone had is just asking if they'll receive a copy of the slides. You should have already received a copy of the slides. If you did not receive a copy of the slides, please email refdesk@sdlawlibrary.org. Again, that's refdesk@sdlawlibrary.org, and we'll get you a copy of those slides. The slides were sent prior to the class, and if you registered right before the class, then you might not have received the slides. And actually, we did get another question. It says, do conservators typically file tax returns for conservatees as POA and then in parentheses when required?
I don't help with conservatorship of the estate, so I'm not really sure. But like normally you wouldn't, you normally, if you're someone's power of attorney, you might not need a conservatorship of the estate. So that is one thing to think about. Although if the power of attorney is not inconsistent with the conservatorship, you could have both, but in theory, having a power of attorney means ideally means you don't need a conservatorship. But anything, if there's estate issues, you should definitely hire an attorney who's competent and has experience helping with conservatorship of the estate.
And do we have time for one more? One more just came in.
Okay.
How does traveling abroad work with a limited conservatorship?
I mean, you should still bring your you should still bring proof of your conservatorship with you when you travel. Most other jurisdictions are going to, at least I think, my sense is that most jurisdictions are going to, take that paperwork into consideration. But if you're actually moving, then you need to work to terminate your California conservatorship and work to apply for conservatorship in your new place, in your new home. But for traveling purposes, I would just try to keep your proof of California conservatorship with you and show it to people if necessary.
I believe that concludes this MCLE class. I just want to say thank you so much to our speaker, Barbara, for such an interesting MCLE presentation. I wanted to thank all of the participants for attending today. Again, I just wanted to let you guys know that you will receive a link to a survey at the end of the presentation. We would greatly appreciate any of those who took the time to give just take a couple minutes and give us some feedback on today's presentation. Again, thank you, Barbara, for a fantastic presentation.
Thank you.
Bye, everyone. Have a good rest of the day.